Good afternoon. This is the hearing of the Municipal Officers Electoral Board for the Village of Midlothian set for January 3rd, 2017. The time is now 3:02 and we are meeting in the Village of Midlothian boardroom. I am Mayor Sharon Ryback, by law the chairman of the Electoral Board. This board has been called into session pursuant to my call after objections were filed regarding nominating papers for candidates for the office of Village Trustee for the April 4th, 2017 consolidated election. By law, the board consists of myself as chairman, the village clerk, Mike Kolstad, and village trustee, Alan Moskal, who is the trustee with the second longest term of service. The trustee with the longest term of service is candidate for trustee in this election cycle and cannot serve on the electoral board. I will call a roll call of members so that the record will reflect their presence. Member Kolstad?
Here.
Member Moskal?
Here.
Chairman Ryback is present. All members of the Electoral Board are present. Also serving as attorneys for the Electoral Board are Dave Freeman and Neil Smith of the law firm of Robert Schwartz, Nicholas, Lifton, and Taylor. There are 4 cases on this board's docket. The board is going to do a roll call for the attendance for the first case. The first case is case number 2017-5, Kathleen Johnson versus Jody Foster. Is there anyone present on behalf of the objector?
Yes, Kathleen Johnson.
Is there anyone present on behalf of the candidate? I ask that you complete the appearance form and return them to the board at this time. Thank you. We will call your case again in a moment. The second case is case number 2017-6, Nora Grutius versus Jody Foster. Is there anyone present on behalf of the objector?
Yes, Nora Grutius.
Is there anyone present on behalf of the candidate? I ask that you both complete the appearance form and return them to the board at this time. Thank you. We will call your case again in a moment. Like we said, if you could just give them to us before you leave today, that'd be great. The third case on the docket is case number 2017-7, Kathleen Johnson versus Steve Pikorz. Is there anyone present on behalf of the objector?
Yes, Kathleen Johnson.
Is there anyone present on behalf of the candidate? I ask that both of you complete the appearance and return them to the board at this time. Thank you. We will call your case again in a moment. The last case on the docket is case number 2017-8, Nora Grutius versus Steve Pikorz. Is there anyone present on behalf of the objector?
Yes, Nora Grutius.
Is there anyone present on behalf of the candidate? I ask that you complete the appearance form and return them to the board at this time. Thank you. We will call your case again in a moment. The first order of business is the adoption of rules for the Electoral Board. These rules have been prepared by our attorney, and we understand that they are based on the standard rules used by electoral boards across the state, including the State Board of Elections, the Cook County Officers Electoral Board, and the Chicago Board of Election Commission. Copies of the proposed rules have been available on the table since 1:40 p.m. today. Does anyone have any questions, comments, or concerns regarding these rules? Is there a motion to adopt the rules?
I'll make the motion.
I'll second.
Member Kolstad?
Aye.
Member Moskal?
Aye.
Chairman Ryback, aye. The rules are unanimously adopted. The Electoral Board's attorney will maintain the official record of the board's proceedings, and any pleadings, motions, and similar documents may be served on the village and its village hall address during regular office hours or during the board's hearings. Copies of any documents must be faxed or emailed to the Electoral Board's attorneys. The rule of the Electoral Board will now be entered into the board's record for the cases. The Electoral Board has, at its own expense, provided for the service of a certified court reporter to record these proceedings. The board will continue this practice during the board's hearings. The board does not plan to have the transcript prepared unless the board needs the transcript for a particular purpose. Should a party be dissatisfied with the board's decision, a complete record will be furnished to the circuit court at the board's expense, but subject to such limitations as may be provided by law. Any person is, of course, welcome to purchase the transcript from the court reporter herself if needed. The assistance of the Village of Midlothian staff may be utilized to assist with the record keeping of the minutes of the Electoral Board's meetings and with the exhibits. I will note the following documents for the records, which will be entered into the official record as an exhibit for each of the cases. The call of the meeting, returns of service of calls on Chairman Ryback, returns a service of call on member Colstead, returns a service of call on member Moskal, returns a service of call on the objectors, returns a service of call on the candidates. Are there any questions regarding these documents? If not, they will be entered into the record as board exhibits. Without objection, any returns of service which arrive at a later date will be entered into the records automatically. The board will also enter into a record for each case of the original objection and the original nomination papers as exhibits. Now the board will consider the first matter, case 2017-5.
Okay, the objectors here?
Yes.
Okay.
My objection is that the candidate, Jody Foster, only submitted 50 signatures. There is no need to do a record check because he did not meet the minimum requirement of 91. In addition, because he is not here according to the letter that was received on December 30th, that if you're a candidate and you do not appear for the hearing at the above time and place, a default judgment may be entered against you, resulting in the finding that the nomination papers are invalid. At this point, I would ask that he be removed from the ballot, because he has not met the minimum requirement.
That is, in my recommendation to the board is this. The candidate is not here, but given the nature of these proceedings, and due to the fact also that we don't have returns of service even showing that it was served yet, that we just continue this matter like we've done with the other cases for a hearing then. And then the signature requirement is an issue of law, which would be considered at the hearing, the next hearing as well. That's my recommendation to the board about how you proceed.
We have no record of service.
We don't have any record of service yet. The nominating papers or the objections, the call was sent by certified mail, return receipt requested, and then by sheriff's office. So those are documents that we just have not received back yet.
How would we reschedule another hearing without verifying that the candidate could receive service?
Well, we've been talking about and we've been scheduling them out a couple weeks. And that is probably going to be sufficient time for them to be notified of the proceedings. We would, once we set that date, we'd send those to them. This is kind of the board's discretion here about how they want to handle the matter.
Does the law state that the candidate could submit additional signatures?
No. As far as signatures go, the signatures are once you submit that on the filing date. That's it. I mean, there's no.
So considering there's no review, the only purpose in rescheduling the hearing would be so that the candidate could attend?
Yeah, I mean, if you desire, we can reschedule it. I mean, it would be. I don't know if the candidate wants to make an argument. The candidate isn't here. We don't know if they're served, and it's kind of a matter of due process, kind of like giving her a chance to make her statement, to make her argument. You could, your rules allow you to do that. Let me put it that way. You're not required to default her today. You're not required to rule against her today. You could, if you chose, you could continue the matter to allow her to come in here.
Him.
Correct. I respect the rules in terms of due process and being sure that the candidate was notified, but without any, if there's not a provision that would allow that individual to submit signatures later, I'm not sure how it would change the outcome. It's just my opinion.
And And so I would hear, the board wants to have a discussion on that issue.
Well, I do know that he wasn't served by the police. They couldn't reach him and get a hold of him over the weekend. So they were back on my desk this morning. Now, the certified ones went in the mail on Friday. I dropped them off at the post office, so those should be delivered within the next day or so.
No, and I think I would have to agree with you. I mean, if he can't submit any more signatures, and after review of his petition, he does not have 91. He is short.
And then for the record, we're gonna have to make sure we're clear about which, we've got four cases here we're talking about, 2017-5, 2017-6,
Right.
2017-7, 2017-8.
I think
And I-
these pertain to the candidate 4, 5, and 6.
Okay, candidate Jody Foster is 5 and 7.
Oh, 5 and 7.
5 and
No, that's right, no,
Five
it's
and
5 and 6.
6.
5 and 6. And, okay. And the only reason I ask is I think somebody referred to it as, the candidate as him. I don't know if it's a.
It is,
It is
okay.
him. Jody Foster is him.
Just want to make sure, we're clear. I didn't know, we're talking about Steve. So,
Neil, before a decision is made, I think something else the board has to consider is, do you have any evidence of the minimum number of signatures in the file right now? In other words, I know the objector has said what the minimum number is, but do you have any evidence so that you can make a finding based upon something that's in your file?
yeah.
You know, do you have an affidavit, do you have something in the file right now that says what the minimum number is in order to make a ruling?
Yeah, and that's kind of why I said that, it almost sounds like, what we're saying is that she's in a bad situation. But we need to also make sure that we have a record that is developed, that if it is challenged and goes up on appeal to the circuit court, that the judge can look at everything in the file and say, they made the right decision. And so we probably will need, like they've said, evidence of signature requirement. They've pled, the objector's petition says 91 signatures in the memo.
But Mr. Smith, all the candidates that we're objecting to, all are required to have 91 signatures, and you have not questioned our comments about 91 signatures. So I understand I think I understand what you're trying to do about due process and giving him a fair shot, but in my estimation, he has not met the letter of the law. He's not in compliance with 91 signatures. He hasn't shown up. And I appreciate what you're doing, but I feel like then he's getting away with rules that don't apply to other people.
Well, I'm not saying that. I'm just giving the board. I'm here to advise the board, and what I'm saying is that I know the board wants to have a decision that is able to be, whatever the decision is it able to be upheld should it get challenged. And I'm just cautioning the board that if this gets appealed, the whole record gets brought up before a circuit court judge in Cook County, and he looks at nothing else but what is in the file, and then he has got to make a decision whether this board made the right decision or not. And my concern is that he won't have the information, the evidence in the record that he needs to say, yes, this board made the right decision, or no, this board made the wrong decision, or this board made the wrong decision. And if he doesn't have that, he's going to reverse this board and send it back down.
So,
And so that's my concern, as I advise the board, is that I don't want I don't want this board to be in a position of getting shot down by the circuit court clerk, and then we're back down here in February, reconsidering. You know
So
what I mean?
that, I understand, I think that's a valid point, but who provides proof of what is already outlined in the state election guide for candidates? That's the minimum number of
Well,
signatures required is
I think
specifically
so.
outlined in that guide.
I think typically the clerk's office would provide the minimum number of signatures needed. So for instance.
Similar to a records check, you could ask them to give you something
Right,
certified that says,
You as a candidate for office, trustee Moscow, may before you ran have gone to the clerk's office years ago and said, how many signatures do I need? And they would give you a number, whatever it was. And you'd say, okay, I need that number plus one at a minimum. So, not that I can give anyone legal advice here, because like Mr. Smith, I represent the electoral board, but in response to your question, I would think for purposes of the record, should this go up in appeal, a circuit court judge would be looking for something in the record. For instance, an affidavit from the keeper of the records of the village, which is the village clerk, saying the minimum number of signatures needed for the position of trustee is 91, which is what the objector is saying. I'm not saying the objector is wrong, I'm saying that her petition is her argument, which may or may not be wrong. It needs to be supported by the village clerk, for instance, saying 91 is the correct number. That's how I would go about proving that the number 91 is correct.
so that's a statement or some type of document from our village clerk confirming that.
Well, that's an
correct
example
number.
of, right, of one way to.
Permission to ask a question? Sorry.
We'll take questions from the public at the end.
And as Mr. Smith pointed out, that doesn't change anything from today to the date of the hearing. Whatever amount of signatures Mr. Foster has submitted is the number. It's not going to change. So if you get something from the clerk that says 91 is the correct number, the next hearing for Mr. Foster is going to be very quick. And again, this is just a recommendation from the attorneys. You do not have to abide by our recommendation. One of the members of the electoral board can make a motion right now to deny his candidacy and, and support the objection that's being made. We don't vote here. We just try to give you some advice, and if you want to make a motion and there's a second, you can certainly proceed.
So do we want to pick another date then for the actual hearing? We could do these probably on the same night.
You know, we've got January 17th and the 23rd as dates that we're already back here, and we could probably could and should piggyback on one of those dates. Be my thought.
Oh, we could do the 17th earlier.
Earlier on the 17th?
Yeah.
6 on the 17th? Because we have a 7.
I certainly for that candidate would be fine. We got the two other objections for Steve. I don't know how lengthy those would be, so we got to think, kind of setting a time. We got to think about. Why don't we talk about the objections to Steve Pikorz? Was in there, right?
Pikorz.
Pikorz. Why don't we talk about those as well, and then set a date that.
That'd be case 27, or 2017-7 and 2017-8.
Okay, so I'll ask the objectors. About the nature of the objections here. This is a more of a standard records check, isn't that right?
We believe that it is beyond a records check. We believe there's widespread fraud in these 10 pages that have been submitted, specifically on pages 4 and 5. It is obvious to anyone looking at it that these signatures are all done by the same hand. They're printed, and there are other pages that have very similar things. And we believe, as a result, the entire petition should be thrown out, and this candidate should be tossed off the ballot for widespread fraud.
There's addresses that are Firestone, the Village Hall, addresses that are not valid.
Okay, so so as far as it's setting a time for a hearing, it's, the objections, 2017-7 and 8 seem like they possibly could be a little bit more involved than 5 and 6. So maybe to give us enough time, we say January 17th at 5 p.m. That way we're not running up against,
7 PM we have?
yeah, we got 7 p.m.
Why not? We can do 5.
Can you do it?
Yeah.
Okay.
So to clarify, at the time, at 5 o'clock on the 17th, is it Foster and Pikorz? Is it just Pikorz? I want to make sure that we're clear as to,
So, yeah, so at 5 o'clock on the 17th, we'll take them in order.
Dash 5, dash 6.
But, yeah, to the 17th, 5, 6, 7, and 8. We'll do that at 5 p.m. And then, of course, at 7 p.m. we've got the other electoral board, 2017-1, 2.
and so your argument again is because he's not here, he hasn't been served, he should be given the opportunity to respond to those that's being served?
Well, I'm not making an argument. I'm just simply saying that our record doesn't have any indication that they've been served.
For this candidate as well? Are we-
That's correct, for Steve Pikorz.
Right.
We don't have any indication they've been served one way or the other.
Well, he knows about it, so he's.
And so-
Your charter engineer right now.
Please, there'll be a time for public comment at the end. So, I'm simply pointing out that, and I'm not making an argument, I'm just advising the board that the considerations they'll want to look into and think about, because they want to make a decision that's ultimately correct and upheld by the circuit court if it gets challenged.
And again, Mr. Smith, for the purposes, if the board decides to have the hearing on the 17th for Foster and for Pikorz, would we still provide you and the board the same timing in terms of our evidence to you electronically and by certified mail or by mail to the board as to our documentation to support why we're asking that these candidates not be on the ballot?
Yeah, you're saying basically you want to submit arguments in writing, I think, just like the other cases.
Correct.
And so it'd be, if the board concurs with this, my thought is that you keep the same briefing date, January 6th, and then January 12th, for the candidate to respond. So, any concerns with that by the board, as far as the briefing schedule goes?
No, it's not.
All right.
Did I understand you were ordering a records check for that one as well?
Yeah, I mean, we'll have to, there are some objections for both of these that would involve a records check. And so, I think we just send it there in the, I mean, for Foster, it may not matter, I mean, right? I mean, she's, if the argument, oh, sorry.
That's good.
It may not matter. I mean, if he's got fewer than signatures, it's not gonna matter. But in kind of in the interest of efficiency, and these are election issues that need to be resolved, it's probably best to just go ahead and send it to a records check for both of these candidates, so that we can come back here and have a hearing, have a fact hearing, have an oral, issue arguments on the law, and take care of it all on that night. And we won't be able to do that if we haven't had a records check for those two. So my thought is that yes, we do go ahead and schedule a records check for those two candidates. All right. Any other concerns with electoral board concerns? Yeah. Any other questions or comments from the objectors?
No, not at this time.
Okay, and then, there were some comments, desire from the public, so just a couple minutes for each.
Valerie Weiskirk, Valerie, last name Weiss as in Sam, Kirch. According to the local election officials handbook, the Leo is not supposed to come up with the total number of signatures. All they're supposed to have on hand is the formula. The total number of voters that voted in the last election, kind of details. So to ask for a certified copy at this point from that same local election official for a statement that's not allowed during the election, I guess is a little confusing as to why it would be needed now, when in fact this board can very clearly do the calculations that everybody else did off of the same formula that's in the local election officials handbook.
I'm not requiring anything. We simply set a new date of January 25th.
You suggested that if it went to court, the judge could overturn it, but I can't see how if the local election official is not obligated to actually calculate out how many numbers of signatures are needed to begin with. And that's fine, that's,
I'll respond.
No,
I'm the one who made the comment, Valerie. You're right, the clerk does not provide an exact number to a candidate, but the clerk is asked to provide how many people total voted in the prior election, then you multiply that by the number that's in the election code. So for instance, I believe for a trustee's position, you need 8%. You're right, the clerk is not going to tell us 8% of some number is 91, to use the example that Ms. Johnson's pointing out in her objections. But the clerk can tell us what the total number of voters in the last election was, and then someone else can do the math. My point was, right now, we don't have any of that information in the record. We don't have that. We're assuming that Ms. Johnson's number is correct. I have no reason to disbelieve it as I sit here, but we have no proof of what that number is. And if Mr. Colson, as the village clerk, for instance, gives us a total number that what we multiply by 0.8 is different than 91, we need to know that.
thank you.
Yes, sir.
Jay Johnson. I have a question. You know, obviously, I've looked over the signatures and the petition pages and everything else. There is obvious fraud, if not downright forgery, on these pages. Is it possible for the objectors to have subpoena who signed the bottom of those pages to show up to those meetings to be asked who was the one who wrote those out, whether it was them, whoever it was on the bottom of those pages, to actually verify, you know, in writing or, you know, when they're testifying under oath, that they were the ones who actually had those people sign. Because I've seen them, there's whole pages where it's the same person that wrote out the whole thing. It's a travesty. And that whoever is the one that's making up this stuff in this village, which is part of the reason, I think, in our village, why there's such distrust, those people should be held accountable for it. I just think that they should be subpoenaed to come before the board and trying to explain what their position is and how they came about these signatures that are out there.
Okay, the answer to that is that the electoral board does have subpoena power by law. The rules say we have the power to subpoena witnesses. And our rules provide that at the request of a candidate or objector, we will sign a subpoena. And then it's the job of the person requesting the subpoena to serve that subpoena along with the attendant costs. You know, as far as service fees, and then as far as enforcement of the subpoena fees, for instance, if the person doesn't show up. So I think that addresses your question about subpoenas.
Well, I think there's something else you need to add, Neil. This electoral board is here to decide whether or not these candidates should or should not stay on the ballot. This electoral board is not charged with, nor does it have the authority or responsibility to determine whether widespread fraud or corruption, some of the words I just heard, exists. You're absolutely right, we have subpoena power, but this is not the Attorney General's office, it's not the state's attorney's office. We don't do investigations into election fraud.
Yeah, and Dave's correct, I mean, we have subpoena power.
As a witness then?
Yeah, the subpoena power would be to bring in a person as a witness, but our, the duty of this electoral board is limited to, in this case, whether signature's valid. And that, I mean, that's a relevant inquiry possibly for a person you might want to bring in here on subpoena. Did you sign, did you sign this? Okay, there's the man in the Iowa shirt.
Lori LaRue, LORI-LHEUREUX. Why can't a default judgment be entered against Mr. Pikorz for not being here?
Well, I mean, we've already addressed that issue, is that we don't have proof of service in the record.
Well, he clearly
And
knows about
and
it.
let me finish. We don't have proof of service in the record, and I've simply advised the board, and they've continued this matter to the 23rd.
He's well aware of it because he sent an
Okay.
employee in here as this hearing started to talk to Mayor Ryback.
Well, I'm not going
Am
to
I
say
wrong?
it.
Mayor Ryback?
Ma'am, that's out of order. This is not a fact hearing, okay? If a candidate or objector wants to call you as a witness for some reason, then they are free to do that. But this is not the place we're going to do that. This is not a fact hearing.
As long as it's on video.
Yes, ma'am.
Ellen Lekovich, what are you going to do to ensure that you're prepared and knowing these people were served the next time so we're not wasting time again?
Well, look, the election code, and just very briefly, I'm going to address the question. The election code sets forth a very short time frame where we've got to have this initial meeting. Okay? So we have to send those out. And it happens all the time in electoral board hearings where people don't get served with their certified mail, or the police officer doesn't get out there. Now, they may be here anyway. But there's really nothing, to answer your question, there's nothing we can do. So,
Maybe we need to make changes.
So I'm just asking, so if it's several more weeks and they've had now several more weeks, how do we not know? Whose job is it to know that they were served? How do you find out they in fact were served? So that in 2 more weeks, we're not sitting here revisiting, oh, those poor folks just didn't know.
again, the statute sets forth a dual system of service, certified mail and actual delivered by the police officer. So those methods are being processed and
Correct.
presumably,
So will someone have that information is my question. Say if it's by certified mail, whose job is it to make sure that we've detailed that receipt and know, and that they have what they need here so that we can get over that hump of them not knowing?
in the chairman's initial comments, she noted that as those green, it's a certified mail, as those green cards come in, they will be incorporated into the record of these cases. They'll be made a part of the record.
Okay.
So that's, the green card is proof of service. As this, if the papers are served by the police officer, his receipt and proof of service will be automatically incorporated into the record for each case.
Okay, so
As
last question
evidence.
then, who makes sure that that's ready the next time? Whose job is it to make sure that that's ready? So it's not in a box or in a file, no one knows. Whose job is it to have that prepared?
Well, the chairman also addressed these in her comments, that the electoral board attorney, with the assistance of the village staff, will make sure that the record is complete.
One more. It's a procedure.
Ma'am, can you please spell your name again for the court?
H-E-L-E-N, last name Lekavich.
One more procedure, please.
Is there anybody else before? Yes, sir.
Carl, does not the city clerk have the election results from the last election? A certified copy?
It's, did you say the county clerk? Or?
City clerk. He should have the results of the last election.
you know, this isn't a hearing today. I mean, this is not a fact hearing, okay? So,
You know, this list is really a waste of time because if you don't give us anything, she's asked you who's responsible for seeing to it that this information is in there so that the next time you'll have the information. You tell us it's the staff. Well, we'd like to know who on the staff is responsible.
That way we can call a day ahead and make sure everybody has what they
no,
need.
no, hold on, we're out of word here. I don't have people's names in the record. Look at, the objectors brought these matters before the electoral board. This electoral board was called into existence on short notice as a result of what documents filed by the objector. They have a burden of proof, and that's what we're going to go forward on the previous days mentioned, January 17th and January 23rd. Is there anybody who would like to speak who's not already addressed the board?
Do I get a chance as an objector?
I'll let the objectors address the board one more time.
Okay, just for our understanding, we didn't enter into this lightly. We've studied a few things, we looked at cases and stuff, and sometimes, in some cases, and I want to know, does this go beyond that next hearing, the circulator, maybe we find that they did some things fraudulent, possibly on the Stephen Pikorz, okay? Sometimes they objected to all the circulator's pages because of that. Does that go beyond that next hearing? Like you said, there's no more after that hearing, but
Yeah, okay, so, and I can't give you advice about how you conduct the hearing, but the next hearing dates, the 17th and the 23rd, are the last hearing dates. Any evidence you want to bring in on those dates, you got to bring it in on that date, or it probably won't get heard. Any oral argument that you want to make gets made on the 17th or 23rd, or probably won't get heard. Anything else? All right, I think a motion to adjourn would be in order.
I'm looking for a motion to adjourn.
I'll make a motion.
I'll second.
Member Mosko?
Aye.
Member Colstead?
Aye.
Chairman Ryback? Aye. We are adjourned.